would you please raise your right hand?
Yeah.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
And I said, I swear. You said
Okay.
to God, though. You said to God. I say, I swear to tell the truth.
Okay.
Play back what you asked me. What I asked to swear to. You say, do I swear to tell the truth, the whole truth, and swear to God?
Ain't nothing but the truth, so help you God.
Yeah, but I'm not asking for God to hear me. I swear to tell the truth, the whole truth, but not to no God.
Okay.
I'm not asking no God for no help. I've been killed to God many times of y'all service people and God anointed gods and human beings' bodies. Yeah, okay. I'm dead, brought back to life many times.
Okay.
That's the second Kevin L. Kirkland in place of the first Kevin L. Kirkland.
Okay.
With the same Social Security number and everything. Y'all government people should know y'all work for the services of United States of America. That's what you mean. You got so many different countries now. It's probably more than what it was when I first came here. It was 11. I don't know what it is at this time. Y'all don't even help me to keep up with the date with the anointed spirits of y'all service. Y'all service help y'all get from spiritual anointed ones alone. And y'all have full spiritual anointed ones in y'all body, in and out y'all body, fighting for y'all service.
Okay. Now, Mr. Reynolds, to Article 1.24, the proceedings and trial in all courts shall be public. However, the right to a public is not absolute and may be outweighed by competing interests, such as interest in security, preventing the disclosure of non-public information, or ensuring that the defendant receives a fair trial. And the reason why I brought that up is because the court is going to conduct an informal inquiry, and which will, the court has to ask questions to determine whether or not there is some evidence that the defendant may have a mental, to determine whether or not there's some evidence to suggest that the defendant is incompetent. Now, Mr. Reynolds, do you—
Incompetent. I was competent when you said that I was trespassing and you brought me to jail on it and you didn't even book me in. I asked the dude that I said I'd take the 60.
Now, Mr. Reynolds, do you, are you requesting that this part of the proceedings be closed to the public?
I believe they froze again, Your Honor.
Okay, hold on a minute. The computer's
That's it all.
Okay,
I was asking for money. I was asking for money on not private property. Trespassing is when you're on private property.
Okay.
A store is not private property.
Okay, now, Mr. Reynolds, the court is going to conduct an informal inquiry, and
in a city ditch, it's not private property.
And Mr. Reynolds, as a court stated pursuant to this case of Lilly versus State 365 Southwest 3rd, 321, the right to a public trial is not absolute and may be outweighed by other competing rights and interests, such as interest in security, preventing disclosure of non-public information, or ensuring that the defendant receives a fair trial. Mr. Reynolds, are you requesting that this portion of the proceeding be closed to prevent the disclosure of non-public information?
Yes, we would request that, Judge.
Okay. The court finds that the parties seeking to close the hearing have advanced an overriding interest that is likely to be prejudice to the defendant. The closure is no broader than necessary to protect the defendant, to protect that interest. And the court has considered reasonable alternatives to closing the proceeding. And the court's findings is adequate to support a closure. And at this time, this portion of the hearing